the applicant? Who is the applicant? Sorry?
प्लांट ये कोई ऑब्जेक्शन जो किया है वही यहाँ पे
ऑब्जेक्शन उनका रिजेक्ट हो गया, तो आप एग्जीक्यूशन फाइल करिए ना, यहाँ किस लिए परेशान है?
लिस्ट में चल रहा है,
लिस्ट में तो चल रहा है, आप एग्जीक्यूशन फाइल करिए, वो अपने दौड़ कर आएंगे, यहाँ पे आप खोज रहे हैं, आपको आपके फेवर में ऑर्डर है ना, एग्जीक्यूशन फाइल करिए जाके।
लिस्ट में चल रहा है डेट, आज नहीं कोई
डेट तो रहेगा, डेट तो हर
डेट रहता है लेकिन
नहीं होगा ना, तो उतना कैपेसिटी हमको नहीं है, मतलब हमको नहीं कैपेसिटी है कि हम 50 केस सेकेंड अपील फर्स्ट अपील डिसाइड करें। नहीं, आप थोड़ा वेट करिए,
आज
देखिए टेकअप होता है कि नहीं। चलिए कॉल करिए,
From daily list and writing for final disposal.
डिलिस्ट करते हैं मैटर को, केस लिस्ट में है, अपने हिसाब से टेकअप होगा, ऐसा हड़बड़ाने से नहीं होगा, हमको बहुत टाइम लगता है चीज़ों को समझने में। चलिए कॉल करिए।
Item 2 second appeal 131 of 1998.
इसी में एडजमेंट रिक्वेस्ट
नहीं
नहीं,
item 1 में है.
यस प्लीज।
This is dependent appeal against judgment of reversal. At the time of admission, in terms of order number 6, 18/11/1998, this substantial question of law, whether on the death of DT.09.02.2026 issued, the plaintiff in law shall be entitled to a share in the estate left by us. Now this is a suit for party. The plaintiff case specific was in para 4 and 5 of the claim that the property involved is recorded in the name of Jumrati Khan. Let only dispute arises with regard to White's law, common ancestral Rizal Vilayat Hussain. Probably at last today I have given the genealogical table.
There is an additional substantial question of law also.
Pardon?
There is additional substantial question of law.
Additional substantial question was kept in abeyance. After hearing evidence arises, your doctor will consider. That is by order dated order dated 10th of December 2025.
What have I stated there?
Para 4 of the order.
Yes.
I was not what you can
Yes, yes. Just a minute.
According to defendant, Walayat Hussain had only 2 wives.
I'm not able to get it. Yes, yes, it is.
Yes.
Yes, it's here. It's me.
According to plaintiff, Walayat Hussain had 3 wives. Bibi Walayatul Khanum, second Firoza Khanum, and third wife Jumrati Khanum.
In this, only 2 wives listed.
2 wives of dependent. Dependent case was that Walayat Hussain had only 2 wives.
So your case was he had 3 wives.
No. Plaintiff's case.
Plaintiff's
It is
case
their
was.
case.
You have your genealogy. You have your genealogy.
Yes.
That is mentioned in appellate judgment, their genealogy.
Appellate court's judgment.
First, while considering stating plaintiff's case, second or third page you have to go. It is part of paragraph of the appellate court's case.
Yes. Okay. 3 wives, right?
Yes. Walayat Hussain had 3 wives. This is the case of the plaintiff.
Where is your genealogy?
This just now I have given the copy.
You don't have a copy for yourself?
This is the copy which we have given.
And this is my plaintiff's case.
You don't have a copy for yourself?
I do.
Yes.
Now let the plaintiffs claim that the land recorded in the name of Jumrati Khanum would that issueless. Here to I नहीं उसमें, but in course of the discussion of judgment, it has come. Jumrati Khanum had died in the year 1962.
Yes.
And plaintiffs are from branch of Mirza Yusuf Hussain, son of Bibi Walayatul Khanum, first wife. मिर्जा यूसुफ हुसैन की पत्नी की दो पत्नियां वलायतुन निसा एंड बीबी हाफनी बेगम.
It should be sufficient to write that they are from the branch of BG.
Yes,
BB
that
Bilati
will
Nation.
be. मिर्जा यूसुफ हुसैन के ब्रांच की ही लोग थे. प्लेटिव 1 एंड डिपेंडेंट नंबर 2. नीचे में देखा जाएगा, लेफ्ट हैंड साइड के नीचे में.
Yes.
They are granddaughters of Amjadi Begum. Natni.
The defendant as well as plaintiff shown here.
Plaintiff number 1 and defendant is performer. Defendant number 2 is performer. And the main defendant was Mirza Abid Hussain from branch of Mirza Jainuddin Hussain. Second branch. The contesting defendant is
No, I am
defendant
not
number.
getting it. Just a minute. Mirza Velayatun had 3 wives. Bibi Velayatun Nisha, Bibi Firoza Khanum and Bibi Jamatun Khanum.
नहीं, उसको निशा नहीं बोला जाएगा, वलायतुल खानम, पहली पत्नी वलायतुल खानम,
निशा लिखा हुआ है यहाँ पर।
हाँ वो
दोनों नाम।
निशा या
विलायतुल निशा है मिर्जा यूसुफ हुसैन की वाइफ, फर्स्ट वाइफ। मिर्जा यूसुफ हुसैन was son of विलायत हुसैन।
You see, the property is recorded in the name of Mirza Vilayatul Hussain.
No, no. The claim of the plaintiff is from the land of Jumrati Khan. Para 4 and 5 of the land they continue.
Please. First wife, second wife.
रीडिंग की जो प्रिंट कर गया थोड़ा दिक्कत है, मैं क्या कह
हाँ
That on the land and properties of Mirza Vilayat Hussain were amicably partitioned before the last settlement among the heirs and descendants of Mirza Vilayat Hussain, and they came in possession thereof, and the parchas were prepared according to the share and possession of the parties. As such, Jamabandi number so and so of Boda Kama, Jamabandi number so and so of Boda Hasan Bani recorded the names of Mirza Ashraf Hussain and Mirza Yusuf Hussain, sons of Mirza Yusuf Hussain. JB number 5 of Boda Town and JB 6 of Mirza Hasan Bani recorded in the name of Bibi Aliman, wife of Mirza Zainuddin Hussain, and Mirza Zainuddin Hussain was in jail due to murder of Mirza Yusuf Hussain, and the suit lands was recorded in the name of Zumrati Khanam in the last service settlement report. That Mosman Zumrati Khanam died issueless in 1962, leaving behind Bibi Amirun Nisha, daughter of Ashraf Hussain and Mirza Abid Hussain, son of Mirza Zainuddin Hussain, and both of them came in joint possession over the suit lands equally. Bibi Amirun Nisha died in 1973, leaving behind her 3 daughters, namely Bibi Mehrun Nisha, Bibi Mehrun Fatma, and the plaintiff, Bibi Sabina Khatun and Mother Amzadi Begum, and they came in joint possession over the sultans with defendant first party according to their respective shares. That Mosmat Amzadi Begum also died in 1981, leaving behind her daughters namely Mehrun Nisha, Mehrun Fatma, and Bibi Sabina Khatun. And they came in joint possession over their respective shares. In 1983, Mehrun Fatima also died, issueless, leaving her 2 sisters, the plaintiff and defendant's second party, who jointly came in possession of their respective share with the defendant first party. The share of plaintiff is 4 and 8 paragraph. That there was no male member in the family of Amirul Nisa, so the defendant's first party used to look after the affairs on her behalf and himself, and also used to partition the Yusuf rights and pay payment of rent thereof. Defendant first party was also the holder of general power of attorney of Amirul Nisa and her mother Mosman Amzadi Begum till her death. That in these days, the defendant's first party has changed his side. This son and sons-in-laws are not liking the plaintiff and her heirs, and is under pressure of them. So he used to malpractice and misuse of produce of the land of the suit land. The plaintiff requested the defendants to partition the suit land, but they did not agree. Cause of action arose in January 1988.
Now, from conclusion of the statement making the plaintiff, it is clear that the land which was recorded in the name of Jumrati Khanam is under party. Now let all together, and the case of the defendant one, that Vilayat Hussain had only 2 wives,
Just a moment.
that another copy of genealogy has been given. In which genealogy you find Beja Vilayat Hussain had only 2 wives, Vilayatul Khanam and Jumrati Begum. And from Vilayatul Khanam, the plaintiff had a granddaughter great granddaughter. Plaintiff number 1 and defendant number 2. Whereas the contesting defendant number 1 is from the branch of Mirza Jainuddin, son of Jumrati Khan, Jumrati Begum. So there is dispute with regard to whether Mirza Walad Hussain had 2 wives or 3 wives. And the defendants have also denied that they are in possession exclusively on the land which was recorded in the name of Jumrati Khanum, their grandmother. Jumrati Begum.
You see, the land was recorded in the name of Jumrati Begum.
Jumrati.
Right? So it is not in dispute that she was one of the wives.
It is not in dispute that
From-
it was not recorded.
No, it is not only that it is not in dispute that it was recorded in her name. It is further not in dispute that she was the wife of Mirza Walad Hussain.
Yes.
That is also not in dispute.
It is not in
What is in dispute is whether she died issueless. This is one thing which is
Yes,
in
or
dispute.
whether he is living dependent as their heir.
That's right. So the point, the substantial question of law as framed. Now, what is the finding of the court? She died issueless or she did not die issueless?
Yes. Consequently, but it will also be considered whether, for the first thing, whether Walad Hussain had 3 wives or 2 wives. And if Jumrati Khanum had died issueless,
Suppose it is found that he had only 2 wives, right? Which one will go amongst the 3?
we are from the branch of Jumrati Begum. Jumrati Begum's son is Jainuddin.
That's right. You are from the branch of Jumrati Begum,
Jumrati Begum.
in whose name the land was recorded.
There was no blood, there was no wife, namely Firoza Khan.
And
Of
the
Walad Hussain.
and Firoza and the plaintiffs are the descendants of Firoza Khanum.
Like plaintiffs are heirs of Walayatul Khanum. First wife. बाएं तरफ के ब्रांच में सबसे नीचे देखा है.
ठीक है. So there is no dispute that these 2 wives were certainly there. There is a dispute as to whether there was a 3rd wife or not, namely Firoza Khanum.
Yes, okay.
Descendants of Firoza Khanum are also party in the proceedings.
No, not.
She died
Not
issueless.
party.
She died issueless.
See, there was no Firoza, namely Firoza Khanum, wife of Walayat Hussain.
So I just want to know, how does it become a material fact? How does it matter whether he had 2 wives or 3 wives?
This has come in the evidence of defendant.
No, I just want to know.
Like if a recorded agent dies, it can state issueless,
Yes.
then the property will be cheated. Even in the Shia law, there is provision of a cheat. But the property was in possession of the defendant number 1, and they are coming in possession since the date of her death, exclusively.
The dispute is that their case is that there is no existence of a second wife, Firoza Khan. My case is that the appellants herein are descendants of Firoza Khan. And they are saying, so what happens that my case is also that Jainuddin Khan, the 3rd wife, she died issueless. So as a result, her share of property, 1/3 share, will devolve on the successors of the first 2 wives. So both of us equitably get divided of 1 share. Now their case is that there is no Firoza Khanum, I am the descendant of Jamurti Khanam, so I will inherit her entire share.
And you are the descendant of?
First
First wife.
wife,
And who is representing the descendants of the second wife, Firoza Khanam?
they are disputing the entire existence. So they are, my case is that they are the
descendants of
second
Firoza
wife.
Khanam.
Yes, yes, Your Lordship.
And this lady had died issueless.
And the third wife, whom they came to be the mother, she had died issueless.
लिखिए जरा. The learned counsel for the appellant has submitted that, as per the case of the plaintiff, Mirza Vilayat Hussain had 3 wives, namely Vilayatum Khanam, Firoza Khanam, and Jamritu Khanam. And they are the descendants of Jamruti Khanam, in whose name the property is recorded. And accordingly, the defendants are claiming to be the exclusive owner of the property involved in the present case. On the other hand, it is the case of the plaintiffs that take it again. The learned counsel for the appellant has submitted that it is the case of the plaintiff that Mirza Vilayatum Hussain had 3 wives, Vilayatum Khanam, Firoza Khanam, and Jamruti Khanam. And Jamruti Khanam died issueless. The property is standing in the name of Jamruti Khanam. And consequently, the property of Jamruti Khanam will go half and half to Vilayatum Khanam and to the descendants of Vilayatum Khanam and Firoza Khanam. On the other hand, the case of the defendant is that Mirza Vilayatum Hussain had only 2 wives, Vilayatum Khatun and Jamruti Begum, and they claim to be the descendants of Jamruti Begum, and consequently, the entire property recorded in the name of Jamruti Begum should go to the defendant. The learned counsel for the respondent has further clarified that the specific case of the plaintiff was that the defendants are the descendants of Firoza Khanam and not Jamruti Khanam.
Now I would like to refer an order, it is 10th of December 2025, by which Your Lordship has directed the lawyer appearing for the respondent kindly turn to para 30. Learned counsel for the plaintiff respondent has submitted that Exhibit 1 to Exhibit 10 are linking evidence to show that Mirza Jalaluddin was son of Bibi Firoza Khanam and not Bibi Jamruti Khanam. However, he submits that he shall place the exhibits on the next day and he has to go through it.
Now you tell us, when we look at the substantial question of law,
Yes.
how does this dispute crop up for decision of this court? As the substantial question of law as framed is whether on death of Bibi Jamruti Khanam issueless, did she die issueless?
She died issueless undisputed.
Jamruti Khanam, undisputed.
Jamruti Khanam के हम लोग ये हैं. We are claiming from Jamruti Khanam and we are coming in possession.
The plaintiff in law shall be entitled to a share in the estate left by him. So if the court has framed an issue that whether on death of Bibi Jamruti Khanam issueless. So there is no dispute that she died issueless. And if there is no dispute that she died issueless,
There is dispute.
no, but that is not the substantial question of law.
That if Jamruti Khanam died issueless, the property will devolve upon whom?
Upon two persons.
Yeah. Now, my submission for the time being from the Shia law problem, there is no provision of property devolving upon the step sons and daughters. Even assuming that the case of the plaintiff true, it is the plaintiff has to prove unity of title and unity of possession with respect to the property. Unity of title is concerned, it will never go to Jamruti Khanam if she died issueless, according to them.
So you want to say that if she died issueless, then the plaintiff is not entitled.
Exactly.
Who is in possession?
We are in possession since her death and even prior to that. She was my grandmother.
From where do we get that this is governed by Shia law?
Exhibit D, without the
No,
document.
there has to be a pleading, no? It is to be governed by Shia law or Sunni law.
Yes.
Where is it?
Yes. It is not in this
So
group.
from where do I see that they are governed by
It
Shia
is
law?
in plaint itself.
It may not be in dispute, but before I go into
Yes,
the
yes.
matter as to whether it's a Shia or Sunni, I must get it from the record that it is they are governed by Shia law.
I will not continue the third line of play. Post title लगाएगा बीबी सवेरा खाना वाइट प्रभाव जामे आलम वाइट कास्ट मोहम्मद मुगल सियासत
Para 1 itself. Plaintiff and the defendants are governed by Shia school of law.
It is undisputed, madam. So now let us see the provision of law. अब तो कुछ देखने को क्या बचा? अब law दिखाइए.
Yes.
The Shia में if a widow dies,
Yes.
then nobody else is entitled to inherit the property.
Yes. We let the Shia law of identity. Chapter 8.
Mountain law दिखाइए. Chapter 8.
Chapter 8, the section of para is 87.
Yes.
The division of heirs, 84.
87 division of shares. The Shias divide heirs into two groups, namely heirs by consanguinity, that is blood relation, and heirs by marriage, that is husband and wife. 88. Three classes of heirs by consanguinity. Heirs by consanguinity are divided into three classes and are each subdivided into two sections. These classes are respectively composed as follows. First, parents, children and other lineal descendants, howsoever, grandparents, howsoever, true as well as false, brothers and sisters and their descendants.
What is this true as well as false?
True grandparents are
And what is
नहीं,
HIs?
इसमें भी चार्ट है, शिया लॉ में भी चार्ट है, इसके बाद एक
What is HIs?
HLS, how low soever.
Oh, how low?
Now can we turn to next page where chart is given. Table of shares. There is no provision of an inheritance by a stepson or daughter. Now, from miscellaneous provision, which applies to CI and to the board, just a page above, variety
No provision for inheritance
by stepsons and daughters.
This property was recorded originally in the name in whose name?
मूर्ति खानम के लोग बच्चे हैं और हम लोग वी आर इनहेरिटिंग दिस प्रॉपर्टी सिंस लॉन्ग द स्टेप
No, I want to know this particular property was acquired by whom?
दिस प्रॉपर्टी वाज एक्वायर्ड बाय विलायत हुसैन
Vilayat Hussain?
Yes.
Correct?
It's-
There was a partition.
नहीं जब मूर्ति खानम के नाम में रिकॉर्ड हुआ था
Record हुआ था. Was there any partition?
Yes,
They were part.
Mirza Vilayat Hussein's property which devolved upon him.
Devolved or there was a partition?
प्लेट में देखा जाएगा कि पार्टीशन का जिक्र है
Partition से devolve हुआ कि ऐसे ही devolve हुआ?
ये ऊपर हमारा 4 में ही देखा जाएगा
All the lands and properties of Mirza Vilayat Hussain were amicably partitioned before the last settlement among the heirs and descendants of Mirza Vilayat Hussain, and they came in possession thereof, and the purchase was prepared according to the share and possession of the parties. As such, Jambandi number was also Goda town, Moda.
That's it. There was a partition.
There was a partition in the first blood branch of Vilayat Hussain. Now I was showing a provision, miscellaneous provision, which is applicable both in CI and Sunni.
Where is it?
That is parative. Section 12. That is miscellaneous provision.
Yes.
Uh,
How do you say it is applicable for both?
What?
How do you say it is applicable for both?
It is applicable to both. Minute. Not 21. That is inheritance, contracts and miscellaneous subject. It is just written in below, Mac Norton, page 99.
Page 99.
Mac Norton उसमें नहीं होगा ये देखा जाएगा
तो कम से कम बुक तो सेम होना चाहिए ना.
बुक तो सेम होना चाहिए मेरा भी मुद्दा ही का है बट पुराना 84 पीछे नीचे में छोटा सा लिखा हुआ
हाँ
है
देख.
ये मिनट इसका
लेकिन ये सब्सिक्वेंट अच्छा.
इसका कॉपी हम निकाले हुए हैं इसका पारा पेज 99 में वो ब्लैक किया हुआ है केस केस रोमन 21
Case 21. Has a woman any right to share in the property left by her deceased stepson? The stepmother is not considered a mother. She is called a wife of her father. She only who bears the child is termed mother. The stepmother is not viewed in the same light as a mother. She cannot take the maternal share of inheritance which is a right appertaining to mothers alone.
How does that apply over here? How does this apply over here?
Second
Upon the
question.
death of the
Yes,
son,
stepson.
upon the death of the son,
Second
stepmother
part.
will not inherit.
Second part, which is regarding
Why?
step relations. Second question also, case 22.
Yes.
On the death of a widow in whose favor an assignment of property has been made by her husband in lieu of a dower, she leaving a son, a daughter, and a daughter.
This is in
by
lieu of a
second-
dower.
My
Does it
submission is
apply?
that there is no provision in Shia law of Mohammed that any stepson inherits the property. From 87, 88, 89.
There is a doctrine of Rad, which is evidently which is an adopted doctrine for both Shias and Sunnis. That is, my case is not being a stepson. This woman has died issueless. She is having no blood relative. Once from Mirza Vilayat Hussain, the property has been amicably partitioned. That becomes the exclusive property of me as a woman.
That's right.
Now I have died issueless. I don't have a blood relative of my own. Ideally, half of the property should devolve on my blood relative. Half of the property should devolve on my husband. If I die before my husband, there is no blood relative. In that situation, the entire property becomes the property of my husband. From my husband, it becomes an undisputed fact that
The
my
husband has expired.
husband has expired.
So therefore, how the property will devolve upon the children of the other two wives? Because for this particular property, amongst the three wives, there is no unity of title and possession. Right? Unless there is some law of inheritance, that if one wife dies, then her share will devolve upon the remaining two. He says that there is no such provision. And it is another thing to say that they are excluded. There is no exclusion. He has not been able to demonstrate that there is an exclusion. In lieu of meher, this is not a divorced wife. She is not a divorced wife. So there is no question of any meher. It is one thing to say that the stepson's property will not devolve upon his mother. Because mother and stepmother are two different personalities altogether.
Yes.
Fair enough. But it is another thing to say that if a stepmother dies issueless, the property will go to the government.
Yes.
Was that your case?
No,
Was that
it is
your
not my
case?
My case is
Then
not.
why should we make out a third case?
No, I am not with the third case.
Then-
My specific case is that we are descendants of Jammuti Begum.
That is a specific case, but that is not the substantial question of law.
That opportunity that we have taken, and it was said that during pregnancy, if it is found.
Yes,
every
sure,
year-
there is no perversity. From where do I get this perversity?
Now that there is a provision of a state, अगर किसी वुमन का प्रॉपर्टी इंटरेस्टेड बन जाती है, that is 111, 111.
See, we will not go into the provision of estate straight away.
I am arguing on the basis of the pleading made by the plaintiff herself. Because she is claiming share in the property of Jammuti Khan. And she
So
is
you
not-
want to say that neither you nor they, nobody will get the property.
No,
If
no.
their case is accepted.
No, no.
If their case is accepted, that there were three
Now,
wives
then-
and one of them she died issueless, then according to you, nobody will get the
No,
property.
no, not they according to me. Unity of title has to be proved by them.
That's right. Now let us see that ultimately we come to a finding. Ultimately, if their case is accepted, if the case of the plaintiff is accepted, that he had three wives, right? There was a partition, and one of them she died issueless. So, according to you, the provision of law would go to the extent that none of you would get any property.
I'm claiming my state to be the son and heirs of Jammuti Khan. Therefore,
You are claiming it's okay. That is not your claim. Now let us see that what will be the status if their case is taken.
Yes, that is what I.
If their case is accepted as correct, then in law, according to you, neither they nor you would get any property.
According to them. Yes. Certainly.
This is what you want to submit.
Now if my specific case has been met out in the written statement,
मतलब ना हम जिएंगे ना आपको जीने देंगे, यही ना फॉर्मूला.
नहीं हम ले जाने ले, we are coming in possession. She had come for partition. She had come for partition of the share which was left by Jammuti Khan. And we are coming in possession, being our grandmother.
You see, there are three classes of parents.
Blood
Three
contains-
classes of parents are there, right?
I was referring written statement.
Okay.
The genealogy given in para 10 of the written statement. Reading हुआ इनका 3 दिन या थी. अब मेरा जो प्रीडिंग है उसको देखा जाए. Where reading? Para 10 of the written statement.
Just. Yes, para 10.
That the genealogical table given in para 3 of the plate is also not correct. It is false to say that Mirza Vilayat Hussain had 3 wives. In fact, Mirza Vilayat Hussain had only 2 wives, Bibi Zumrati Khanum and Bibi Vilayatun Khanum. It is also false to say that Mirza Zainuddin was born of Bibi Firoza Khanum. The fact is that Mirza Zainuddin was born of Jamruti Khanum. Mirza Vilayat had only 2 wives, namely Bibi Zumrati Khanum and Bibi Vilayatun Khanum. He had no wife named Mirza Firoza Khanum. This fact has also been admitted by Amjadi Begum in RM case number so and so. The correct genealogical table is given below.
And who is Amzadi Begum?
अब इसमें एक लाइन है आपने ऐड किया हुआ है फिरोजा खानम की जस्ट बात 7 लाइन में वो थोड़ा हाथ से किया हुआ पढ़ा देगा.
As this fact has also been admitted by Amjadi Begum in RM case number 205.
And Amjadi Begum was Nani of the plaintiff and defendant.
Just about Amirul Nishar is Amjadi Begum.
Wife of Ashok Singh.
Amzadi कहाँ लिखा है?
From Vilayatan Khanum side.
विलायतन खानम सईद अमजदी हुसैन.
You know that we have Vilayatan Nishar.
अमजदी बोल के तो कोई नाम ही नहीं.
Amjadi Begum is there.
अशरफ
You see, Vilayatin Hussain, we have Vilayatun Nisha, then
You know that we have Mirza Ashraf Hussain.
Hashim Begum, Mirza Yaqub Hussain,
यासु
died
the
issueless.
case
Amzadi Begum, Mirza Ashraf Hussain.
उनकी बेगम थी अमजदी बेगम.
ठीक.
अमजदी बेगम की बेटी थी अमीरुल निसा वो ब्रिटिश घर और उनकी बेटियां हैं प्लेंटिफ नंबर 1 और डेप्यूटी नंबर 2. And that correction made by hand was Exhibit D. Revenue Division, case number 209 of 1976-77, when there was no dispute. And the statement made by Amjadi Begum, their grandmother, in that case was that is Exhibit D.
She made a statement that only there were only 2 wives.
May I pass it?
No, I just want to know. I'm looking at the substantial question of law. I still want to know why do we need to go into this?
Therefore, when there
Now there is an admitted fact that she died issueless. The question is whether the property will devolve.
No, the issue that this is not my case. My
It
case.
may not be your
It
case,
is case of
but
plaintiff.
that is a substantial question of law. क्वेश्चन ऑफ लॉ क्या बनवाए हैं? आप ही बनवाए हैं ना, कोई
उसी
और
को-
बनवाया है?
उसी को तो करेक्शन के लिए हम एप्लीकेशन
Correction
दिए
of-
थे बिकॉज केस पेज में हमें उसी को करेक्शन के लिए थे। वो निकालो ना, ये निकालो।
वो हम देख रहे हैं।
देख नहीं लेंगे उसी की वजह से the doctor will keep the matter in abeyance after the hearing to be considered after hearing. इसीलिए हम वो रेफर किए पाए ऑर्डर नंबर
Exhibit 10 has not been considered by the courts. This exhibit, whatever you are saying,
Yes, this was considered by trial court and therefore suit was dismissed.
and the appellate court has not considered
Not
it.
considered
Not considered it at all
at all. Exhibit D has not been considered at all.
by the appellate court.
Exhibit 7 or Exhibit 7 was filed on their behalf, plaintiff, and it was considered by the appellate court. Whereas Exhibit D was considered only by trial. Well, I'm taking help of it then.
देखिए ऐसा है ना सर, सब्सटैंशियल क्वेश्चन ऑफ लॉ आप अभी ओपन रख के ना इस तरह से मेरिट पे बहस नहीं कर सकते। पहले तो आप हमको सब्सटैंशियल क्वेश्चन ऑफ लॉ पे बता दीजिए कि भाई yes it is required to be framed and let me hear her on this. You can't keep it open and then argue the case.
Will it? Your Honor?
Because we had filed an application that was, now there is a misconstruction of, Your Lordship, kindly take note of the exhibits. Total misconstruction of exhibits 3, 6, 7, 7 by 1, 9 and 10, and exhibit D. Now, I'll show from the trial court relies on these and discusses each and every of these exhibits, whereas the appellate court's judgment, Your Lordship, I may be allowed to read it, and then Your Lordship may see as to whether it is a total misconstruction. Now,
And what is the proposed additional substantial question?
whether this has misconstruction, whether the appellate court has misconstrued the exhibits 3, 6, 7, 7 by 1, 9 and 10 and exhibit D.
This is the additional substantial question.
Why? Because the trial court had discussed all these and then came to a finding that the plaintiffs have not been able to prove their case that that Jamurti had died issueless and there were 3 wives. And there was any wife with the name of Roja Kanama. This the plaintiff had failed to establish. Whereas this has been reversed, discussing all these, but Your Lordship, allow me to read the appellate court. I'll show as to how. Now, the appellate court, I'll say only 2 lines. Appellate court says there, with regard to referring to a previous title suit, a plaint was filed, and judgment of that title suit was also filed. The appellate court says relies on our statement, so-called statement, which has been quoted by the appellate court in para 9 and 10 of the judgment, but it does not discuss the. I may be allowed. It says that I have admitted in my evidence or in my pleading, I have admitted that there were 3 wives. And for that purpose, it is taking, referring to exhibit 9 and 10, which is the judgment of a previous suit. And whereas on the same suit, the plaint is already there. So my admission has to be seen from the plaint and not what has been referred as my case in the judgment. So Your Lordship may only allow me to read the discussions made by the appellate. From para 9 of the appellate court, it frames three questions for determination. The first was whether Vilayat Hussain had three wives, Bibi Vilayatun Nisa, Bibi Firoza Khanum and Bibi Jamruti Khanum, or had only two wives, namely Vilayatun Khanum and Jumrati Khanum, and whether Mirza Jainuddin was the son of Bibi Jamrati Khanum or Jumrati Khanum died issueless, and whether the plaintiff appellant have got unity of title. Now, while discussing whether he had three wives and whether we were the descendants of Jumrati or Firoza, now the appellate court in point number 1 it discusses, and then Your Lordship may kindly skip all those portions. It discusses the witnesses and then he starts the documentary evidences in page para 14. Para 14. May I read? In para 14, para 15. Now here the documentary evidence is being considered. Now let us consider the documentary evidence. Exhibit 1 is the certified copy of bail application filed by Mirza Saqir Hussain and others accused person, wherein in page 2 genealogical table Jumrati Khanum has been shown as the sole wife of Vilayat Hussain, and Mirza Jainuddin and Mirza Yusuf have been shown as their sons in the bail application dated 22/11/1989. Exhibit 3 is the certified copy of the plaint. This is misconception of the plaint of title suit number 2 of 1985, wherein the same genealogical table has been given by Abid Hussain. That is at para 11. The genealogical table has been given as follows. Now in that the wives are not mentioned. I'll make it very clear. Your Lordship would find it from that itself. Other part of the genealogy is not mentioned by me here. It appears that Abid Hussain, the original defendant of the present case, had filed title suit number 285 against the plaintiff appellant Sabra Khatun and her sister Bibi Mehrun Nisa, praying for declaration that suit property of that suit belonged to him, and the defendant have got no means or right of title over the same, and they are not entitled to take delivery of possession or that in execution of execution case number 580 arising out of title suit number 76 of 76. After the death of Abid, the present respondents were substituted as plaintiff in place of Abid Hussain in title suit number 285. Exhibit 9 here, Your Lordship, of the same plaint. Exhibit 3 is the plaint. Exhibit 9 is the judgment of title suit number 2 of 85. From the perusal of para 3 of Exhibit 9, it appears that the plaintiff of that case, respondent hearing, made out a case that Mirza Vilayat Hussain had three wives. Bibi Vilayatun Khanum, first wife, Bibi Firoza Khanum, second wife, and Jamurti Khanum, third wife. Whereas no such statement is there in the plaintiff, but it is only referred in the judgment.
In the judgment it is mentioned.
In the yes.
And
Judgment it has been mentioned as our case.
That is
It has been that I'll not shy away from the fact that it has been mentioned in the judgment, but while stating our case that this was our case, and this has been now when Exhibit 3 was already there on record. So the appellate court does not take the statement made by me in my claim, but it relies on the judgment that I have made out such a case in the judgment. Now then I may be allowed. This statement of fact is carried out in para 2 of Exhibit 10 of judgment entitled Appeal number so and so. Further, Exhibit 9 and 10, it appears that it was the case submitted before the court that first wife Vilayat got a son Mirza Yusuf, and from second wife a son Mirza Jainuddin. From the above, it becomes clear that there are statements of admission in judgment between the same parties, and it is admissible under section 18 of the Evidence Act. There is no explanation to this statement of admission of fact in Exhibit 9 and 10. It is well settled that admissions, unless explained, furnishes the best evidence. The learned counsel for the appellant cited so and so. The lands of suit are not the subject matter in this suit. On 1/4/1998, the learned counsel for the respondent had filed an application praying that the original record of title suit number 285 may be called from the Honorable High Court for verification of Exhibit 3 of the plaint of title suit number so and so. So this is misconceived, Your Lordship, or it was misconceived application on our behalf, because certified copy of the plaint was already there, so it was not required to have further called for the records. It appears that this appeal was heard on different dates, and all these things now is being discussed. After approximately 7 to 8 lines, Your Lordship, may kindly take up. In para 3 of the application, it has been stated that the plaint of title suit number 285, exhibit 3 is very faint. This is not the fact. The exhibit 3 is clearly visible. Further in the application, that has been stated that as the case of the respondent in title suit number 285, that Mirza Vilayat Hussain had 2 wives, Vilayatul Khanum and Bibi Jamrati Khanum. And Bibi Jamrati had only 1 son, Mirza Zainuddin, and Abid is his son. This again a false statement made in this application. There is no such statement in the entire body of the claim. If at all there was a mistake recording in the judgment exhibit 9, para 3 and exhibit 10, para 2, the respondent should have applied immediately before the concerned court for review or correction. But instead of doing so, in this application, as it has been filed when the certified copy of the judgment are on record, there is no requirement of verifying the correctness of particularly when there is no dispute raised by the respondent before the court. Now, can I explain this statement, this reason? Now, here the court says that the plaint is already there on record. If there was any misquoting of fact on our behalf in exhibit 9 and 10, then we should have applied immediately before the court for correction. Now, in that suit, this particular genealogy was never in dispute. It was never in dispute. The suit property belonged to the branch of the first wife itself. It was from the first wife's branch, the entire dispute was related to that property. So, in that, the dispute was not as to whether he had 2 wives, 3 wives. So, if any statement was there that I was not required to file an application for correction, because that was not relevant for deciding that particular suit. Now, second, my submission would be that
This is with respect to exhibit 9, exhibit 10 and exhibit 3.
Yes. And then I may be allowed to read further, where there is
Keto, the learned counsel for the appellant has submitted that exhibit 3 is the plaint of the earlier suit, being title suit number 2 of 1985, which was not relating to the property involved in the present case, but was relating to the property which devolved upon the first wife.
which was recorded in the name of descendants from the first.
Recorded in the name of descendants from the first wife, and the corresponding judgments and of the trial court and the first appellate court are exhibit 9 and 10. He submits that the learned first appellate court in the present case has recorded that there was an admission on the part of the defendant that Mirza Vilayat Hussain had 3 wives. The learned counsel has submitted that in the plaint there was no such admission. Even if there is some error in recording in the first appellate court's judgment and the second appellate court's judgment, the same has no bearing in the matter, as the dispute as to whether Walitul Nisa had 2 wives or 3 wives was not the subject matter of consideration and was not a part of the issue decided by the court.
And exactly this is the finding of the trial. Then I may be allowed to read.
What about exhibit D?
हाँ बता अब उसके 5 लाइन के बाद मतलब वो जो review I did not find any review and all those. It is admitted that is उसी जहाँ पर
Internal page 19.
I have typed copy. I'm not sure.
Para number?
Para number is 17.
Yes.
17 and it is it is admitted. Accordingly, my contention was rejected with regard to Exhibit 9 and 10.
That's
Then it starts, it is admitted that the suit property is recorded in the name of Jaimurti Khanam, White Para 11 of the written statement, Exhibit 6. I was reading 7 to 8 lines prior to that I should have applied immediately before the concerned court for review or correction, but instead of doing this, application has been filed and the certified copy of the judgment are on record. There is no requirement of verifying the correctness of, particularly when there is no dispute raised by the respondent before this court. And after 5-6 lines of this particular portion,
These statements
it
are
is
admissions
admitted.
in judgment.
It is admitted.
Not able to get that. We don't
I may be allowed to read the in continuation where I was reading.
You read para 17 on 1/4/1998.
Your Lordship, what that there is no such statement in the entire body of the plaint. If at all there was any mistake recording in the judgment, para 3. This I have referred.
Yes, you have referred, but I am not able to get back to it. This statement of fact is carried in para
Yes,
2 of
yes.
Exhibit 10 of the judgment. Further, in Exhibit 9 and 10, it appears that it was a case submitted before the court that the first wife Ilatun got a son Mirza Yusuf and from second wife a son Mirza Zaniruddin. From the above, it becomes clear that these are statements of admission in judgments between the same parties and admissible under Section 18 of the Evidence Act. There is no explanation in this statement of admission of fact. This is where I am. Just above, just last portion of para 16.
Para
16.
yes, and then para 17 it starts on 1/4/1998.
That's right.
And then the discussion is there with regard to the Exhibit 3, Exhibit 9 and 10 in this para 17 itself. And then that concludes with the lines that accordingly it is rejected. This is the discussion with regard to Exhibit 3, 9 and 10. Accordingly it is rejected. Then it starts with it is admitted.
Accordingly, it is rejected.
Yes,
Para 18.
it is para 18. Para 18. It is admitted. It is admitted that the suit property is recorded in the name of Jaimurti, White Para 11 of the written statement. The Exhibit 6 is the purchase of JB number 26 of Hassan money recorded in the name of Jaimurti Khanam. The learned counsel drew my attention to boundary of plot number 35 and 47. From perusal of the same, it appears that in the northern boundary of those plots, name of Mirza Zainuddin appears. This leads to inference that Zainuddin was the son of Jumrati. Then, in the boundary, name of Zainuddin should not have been mentioned. This question had in the last date also this. What it is coming to the conclusion. From the perusal, it appears that in the northern boundary of those plots, name of Mirza Zainuddin appears. This leads to inference that Zainuddin was, it would be if Zainuddin was the son of Jumrati, then in the boundary, name of Zainuddin should not have been mentioned. Here, the appellate court means to say that mother and son, if they are mother and son, then they could not have properties adjacent to each other. This is the inference. Then Exhibit 7 is a mistake list dated 26/3/2025. 25. From the perusal of serial 75, it appears that Abid Hussain had made a statement that his father is in jail, so his mother Musammat Aliman, his wife of Mirza Jainuddin, be recorded. At serial 76, the statement of Ashraf Hussain of that separate Jamabandi according to possession may be recorded. It further appears that Ashraf Hussain and Mirza Yusuf Hussain, the heirs of the first wife, Musammat Aliman, wife of Jainuddin and mother of Abid Hussain, and Jain Jumrati Khanam have signed on it. It suggests that in 1925 the properties were recorded in different Jamabandi, and Abid prayed that the name of his mother be recorded in place of his father, and accordingly his mother's name appears.
This is which generation? The next generation.
नहीं नहीं वो इस अपने बारे में बोल बता your lecture में see the names from the genealogical table.
Yes.
If
Who was in
Jain-
jail? Who was in jail? Mirza
Zainuddin Hussain.
Zainuddin.
Father
Zain,
of Abid Hussain.
father of Abid Hussain. So the property was recorded in the name of.
I may be allowed to read the lines once again and then the lecture may see them with the genealogical table. From perusal of serial number 75, it appears that Abid Hussain has made up. Who is Abid Hussain? He is the admitted son of Jainuddin. He is son of Jainuddin. That is not in dispute.
Yes.
Abid Hussain has made a statement that his father is in jail. That means Jainuddin is in jail, and so his mother Musammat Aliman. Aliman is the wife of Jainuddin. May be recorded. At serial 76, the statement of Ashraf Hussain of that separate Jamabandi according to possession may be recorded. It further appears that Ashraf Hussain and Mirza Yusuf Hussain, heirs of first wife, Musammat Aliman, wife of Jainuddin, and Jumrati Khanam have signed on it. It suggests that in 1925 the properties were recorded in Jamabandi, and Abid prayed that the name of his mother may be recorded in place of his father, and his mother's name appears. If Jainuddin was the son of Jumrati, the name of Jumrati would not have been mentioned separately. This is the inference.
Rightly so.
But
Rightly so.
no, why it is saying so? Now Jainuddin's mother's name is not being mentioned. Here Abid is mentioning only that because his father Jainuddin is in jail, therefore his mother, namely Bibi Aliman's name may be mentioned. Yes, there is no question of grandmother's name may be recording of grandmother's name, because the Jumrati according to us was grandmother. Even according to their case, it was not the mother of Abid.
If Jainuddin was the son of Jumrati,
Yes.
so there was. Then they say that if Jainuddin was the son of Jumrati,
Yes.
then there was no question of recording of anybody her name.
What it is saying, we must repeat it once again. If this is only inference is being drawn. If Jainuddin was the son of Jumrati, the name of Jumrati would not have been mentioned separately. Now here the separate recording is whose name? Now genealogical table. Abid is saying that please, my father is in jail, so please record my mother's name, Bibi Aliman's name. This is the only statement which is made. So how can this be inferred to say that if Jainuddin was the son of Jumrati, then his mother's, then Jumrati's name should have been entered? I don't know from where this particular line is being entered.
Because the entire inheritance of Zainuddin was coming from a different lady altogether, that is Firoza Khan.
It is Abid's statement, it is not Jainuddin's statement. If Jainuddin's statement would have been there, that my mother is so and so, please record my mother and some other mother's name he would have mentioned, then the matter would have been different. Here, admitted position is that Jainuddin had a wife, namely Bibi Aliman. This is not disputed portion. And Jainuddin and Bibi Aliman had a son, namely Mirza Abid. Now, Abid is filing an application, not Jainuddin.
So if Abid is filing an application
Yes.
saying that Jainuddin is in jail, so the name of Aliman should be recorded.
Yes,
If the just a moment, if the property was that of Jamruti, and if Jainuddin was the son of Jamruti, then there was no occasion to refer the name of Jainuddin on the property. Straight away, the Jamruti's Khanan's name should have been there.
No, this was not a property of Jamruti. This particular inference is with regard to some other property. Now, here the only inference from that document the appellate court is drawing that if Jamruti was already there, then her name should have been entered and not of Bibi Ali.
Naturally. If Jamruti was already there, then her name should have been entered.
But-
Where was the occasion of entry of the name of Aliman?
But yes, but because Jainuddin was alive, if Jainuddin's second branch is already alive, then why would I mention that please record it in my grandmother's name?
Because it is recorded in the name of grandmother.
No, this property, this is not with respect to this particular property. This the appellate court is not saying that this is related to the same property. It is only for the purpose of coming to the conclusion as to whether they have three wives and
It
whether
is
Jainuddin was
relating to which property, and it is relating to which proceeding.
I'll come to that. I'll come to that.
25 and 26 is in the name of Jamruti. And 5 and 6 was recorded in the name of Abid's mother, which itself proved that because inheritance was completely separate. The ladyship, if I may just take 1 minute to explain one thing. From the first wife, none of the males were surviving. I personally also, I am a descendant of Amiru Misa. And all these women were Pardanashi. From the second wife, my case says that it's Zainuddin, since Zainuddin murdered Yusuf, which is why his wife's name was recorded on a certain plot, which is itself evident from paragraph 18 of the appeal. That was the dispute also that was raised.
He murdered Yusuf.
Yes.
Who is Yusuf?
Yusuf was the son from first wife.
And that portion is not in this. The descendants from first wife, there is no dispute.
So logically, going by that, the first wife is there. So the separate name recording was inexplicable even at this stage. If it is an amicably partitioned property, why separate for grandmother, separate for mother? That is only because I trace my genealogy to the second wife, Firoza Khan.
I may be allowed to place further and then para 19. It appears that the learned court below has discarded exhibit 9 and 10, saying that there is no finding in the judgment that Vilayat had three wives. He had not considered the statement of admissions of respondent made in exhibit 9 and 10 in the light of section 17 and 18 of the Evidence Act. Likewise, exhibit 7 series have been discarded on the ground that there is no mention of Vilayat had three wives. It is a revenue record and it shows that division of the property in the three branches. No doubt exhibit 7 and 7/1 are not conclusive but certainly supports the appellant case as discussed above. For disbelieving exhibit 9 and 10, the learned court below has given another ground by para 13 of the impugned judgment that the plaintiff has to prove his case and he cannot take the advantage of weakness of the defendant. In this case, no question of weakness of the defendant arises. It is the admission made by the defendant in another litigation between the same party, and still it is pending according to them before the Honorable High Court. In para 14 of the learned trial court has stated that PW1 and PW9 have been cross-examined on the point of wife and son, which appears to be error of record. I have discussed and found the contrary. Exhibit 8 series are the rent receipts filed on, by the plaintiff, which supports their possession, which are not being taken into accordingly learned trial court. The evidences of DW6 and DW7 have not been considered in the light of section 50 of so-and-so. The learned concept for the respondent submitted that Amjadi Begum, maternal grandmother of plaintiff, had filed. Now this is one. This again I have placed exhibit C. Have submitted that exhibit Amjadi Begum, maternal grandmother of plaintiff, had filed RM case number so-and-so, exhibit D, wherein she has admitted that Vilayat Hussain had two wives, Jumrati and Vilayat Tun. It appears that genealogical table has been given showing two wives, and Jumrati has been shown as the first wife, which is not the case of either party. Moreover, the plaintiff is not claiming through Amjadi. This statement is again. Now, her name may kindly be seen from the genealogical table. Amjadi is the own grandmother of the plaintiffs. She is mother of Bibi Amirul Nisa, grandmother of the plaintiff. She was wife of Mirza Ashraf. Moreover, plaintiff is not claiming through Amjadi Begum, as such her statement is not binding upon the plaintiff. In the said exhibit D, there is nothing to show that Jainuddin was the son of Jamurti Khan. So the basis of exhibit C cannot be concluded that Jainuddin was the son of Musammad Jumrati Khan. The learned court below has stated that because Amjadi is the name of plaintiff, it cannot be overlooked without considering as to how it can be used against the plaintiff. I find that exhibit D, Amjadi has not admitted that Jainuddin is the son of Jumrati Khan, so it is not helpful to the respondent. Exhibit A series are the rent receipts. Now, considering the
Now you
able
tell us,
evidences and
the
documented
property which stood in the name of Mirza Vilayat Hussain, what was the area of the property? And how much rent receipt each one of you have produced? Because there was a partition or not?
Yes.
There was a partition, it is not in dispute. How was it distributed amongst the three? 1/3 or half and half? If it is 1/3 each, it goes to show that there was a third wife. If it is half and half, there is no problem.
that concept is not there in Mahatma. Because
The concept is not there means what? You say that this property was divided amongst three wives. They say that it was divided amongst two wives.
This is not the case. I don't know.
You say this is what is there in the plaint, that it was divided amongst the three wives. We are not going to enter into so much of discussion about the first appeal mat bana de.
But
ऐसा
this
purpose
is
है.
reversal. If it would not have been reversal, matter would have been different.
What were you doing with
The trial court.
what were you doing with the substantial question of lawless?
This is the reason I had filed and I had granted me a liberty.
What legal?
And this liberty.
I'm not, you see, there are
Therefore, I
so many
say
documents. It
whether-
is not, you see, it is not just the judgment and the plaint which has to be taken into consideration. There are so many documents on record which have been discussed. You want to open a trial court over here?
No,
We will
but-
examine all the documents and come to a finding.
No, I have mentioned very
Not in a second.
specifically I
Not
have
in a
mentioned
second.
very specifically the judgments.
What do you mean
Uh,
judgments? 3, 9
exhibit-
and you see, if it was exclusively based on exhibit 3, 9 and 10, the matter would have been different. But it is based on so many documents.
So many documents, but each of the document is misconstrued.
No, what do
The
you
appellate
mean
court.
each is
Now
misconstrued?
the trial court.
Exhibit
chairman
D is not
can
misconstrued. Exhibit D? What do you have to say to
see-
exhibit D?
Exhibit D is the application filed by Amjadi herself, where she only says two wives of Vilayat. How can now they say that she had 3 wives? Their entire case is that Vilayat had 3 wives. Is it not their case that Vilayat had 3 wives? Their case is dependent on that. And the Amjadi herself files an application, shows that she had only 2 wives. So what would be the inference then? If he had only 2 wives.
This
she
is
has-
exhibit D.
Yes, exhibit D. And the appellate court discards that on the ground that here the dispute is whether, essentially dispute was whether Vilayat had 3 wives or 2 wives. This was the crux of the entire dispute.
So what do you have to say with respect to exhibit D? That has not been considered.
No, what he says
How
that
does
no,
he consider exhibit D?
No, misconstruction. Therefore, I say that if there is a misconstruction leading, it is so vital for deciding the absolute question itself.
Where is the discussion of exhibit D by the first appellate court?
Yes, that I read it just now, but I'm reading now.
Para 20.
Para 20.
Yes, please read it.
The learned counsel for the respondent submitted that Amjadi Begum, maternal grandmother of plaintiff, had filed RM case number 209 of 1976, Exhibit D, wherein she has admitted that Vilayat had 2 wives, Jumrati and Vilayatun. It appears that genealogical table has been given showing 2 wives, and Jumrati has been shown as the first wife. It is not the case of the
Which
Only
is not
because-
the case of either party.
No, but it is only because she has been shown on the left side of the genealogical table, therefore this is not the case.
Left means what?
Yes.
First wife.
Moreover, the plaintiff is not claiming through Amjadi Begum. As such, her statement is not binding upon the plaintiff.
Plaintiff is claiming through Amjadi Begum.
Yes.
I'm claiming through Bibi Amiru Bisa.
No, Amjadi Begum is your.
She's my great grandmother.
Yes, so you are claiming through Amjadi Begum only.
Mirza Ashraf Hussain and Amjadi Begum. I'm claiming, I'm claiming directly my mother in this case.
If your grandmother is there, you will disown the grandmother. You are claiming through Amjadi Begum. You are claiming, you see, you are.
But your relation, there is another point that it said that the first wife, Jumrati, but that is not the case. She is admittedly she is not the first wife at all.
Maybe not the first or second, merely because the name of a person is it mentioned there that she is the first wife or the second wife? No. Exhibit D, is it mentioned that she is the first wife or the second wife? You read it further, please
Yes,
continue.
Jumrati has been shown as the first wife.
Where is it? Show me from exhibit D. Show me from exhibit D that she has been shown as the first wife.
We have wife number 1 and wife number 2. This is it. But it only mentions that there are 2 wives. It does not mention 3. No name of Firoza Khan, which is the entire case of theirs that we are the descendants of Firoza.
But it does not mention that Zainuddin is the son of Jamruti as well.
It may not mention. The point is, the issue is whether he had 3 wives or 2 wives. Right? That is the core issue, whether he had 2 wives or 3 wives. It is not your case that they are completely alien.
Yes.
It is not their case. It is not your case. Isn't it?
Yes,
You continue, just इसको complete करिए. इसको complete करिए.
हाँ. Moreover, the plaintiff is not claiming through Amjadi Begum, as such statement is not binding upon the plaintiff. In the said Exhibit D, there is nothing to show that Jainuddin was the son of Jamurti Khan. So, on the basis of Exhibit D, it cannot be concluded that Jainuddin was the son of Muhammad Jumrati Khan. The learned court below has stated that because Amjadi is the name of plaintiff, it cannot be overlooked without considering.
Is the nani of plaintiff. The learned court below stated that because Amzadi is the nani of plaintiff.
अच्छा मैं मेरा टाइप I do apologize. Nani of plaintiff, it cannot be overlooked without considering as to how it can be used against the plaintiff. I find that Exhibit D of Jadi has not admitted Jainuddin is the son of Jumrati Khan. So it is helpful to respondent. It is not helpful to the respondent. Exhibit A series of the plaintiff. Then now he comes to the conclusion directly. Considering the oral evidences, the documentary evidences and the facts discussed above, I come to the conclusion that the plaintiff appellant had been able to prove that Vilayat Hussain had three wives. Vilayatul Nisa, Bibi Faroza and Bibi Jumrati Khanam, and Birja Jainuddin was not the son of Bibi Jumrati Khanam. Further, Jumrati died issueless. Accordingly, the finding of the learned court on this point is reversed.
So this is what you have to say on the additional substantial question.
Yes, that there is total misconstruction of Exhibit 3, 9, 10 and Exhibit D also.
And you suggested substantial question of law, you read 9/12, order dated 9/12/2025.
No, this I had withdrawn on the ground that has been mentioned in the previous.
Where is the fresh substantial question of law? Additional.
My contention is, I have already placed that if there is misconstruction of Exhibit 3, 9, 10 and Exhibit D leading to the perversity of the judge, the misconstruction has led to misconstruction is.
Yes, madam, you just tell us. If there is nothing mentioned in the plaint, Exhibit 3, and if it is mentioned in the judgment regarding the genealogy, is it binding? Or is it a finding of fact? Was there any issue in the previous suit about the genealogy? Was there any issue about the genealogy in the previous suit? You see, it's a judgment of reversal, and the documents are for consideration. So, if there is an issue in the previous suit as to what is the genealogy, there was no dispute on the point of genealogy in the previous suit, as they say. Was there any dispute on the point of genealogy in the previous suit?
Then the distributed land in question is also important.
The property was not the same.
Which is why.
Therefore, if in a previous suit some genealogy has been mentioned, right? Some genealogy has been mentioned in the previous suit, and that was not the issue before the court, right? Then will it bind anybody? Will that bind anybody, madam?
I'm harping on the rent receipts, firstly, and secondly, on addition, if
You see, they are on the additional substantial question.
is that admitted to
No, that has not been admitted. They are still on the additional substantial question of law, because we had observed that if any perversity is found during the course of hearing, then an additional substantial question of law will be framed. Now they have placed the entire judgment so far as the genealogy is concerned, and then they say that the court has relied upon Exhibit 3, 9, 10, Exhibit D, right, to come to a conclusion that there were 3 wives and not 2 wives.
Your ladyship, there is also a deposition by PW1.
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 Let us see.
If I may.
PW1.
PW1. He happens to be the son of Karnai Ross, who used to manage the property with Amit Hussain collectively. So, in his deposition,
He is your witness.
yes. And moreover, from the DWs, from the witnesses on their side, they are all our neighbors. They are saying they do not explicitly know whether there were 2 wives or 3 wives. Even the witnesses on their side.
If there is conflicting oral evidences, correct?
Yes, yes.
Then the documentary evidences is to be seen.
No, Your Ladyship. On one hand, there is a clear-cut factual admission that yes, since my father was working, I knew that 3 wives, and we were managing it till my father was alive. The person did plan.
From where do you get admission? Show me the admission. Who is admitting?
Biplal Mandal.
Biplal Mandal, who is he?
PW1.
PW1.
Yes.
His isolated statement is of no value.
So, Your Ladyship.
Nobody from the family has been examined?
From the family, my husband was examined and Hashmi and all the others are neighbors, Your Ladyship.
You are claiming that there were 3
3 wives.
wives.
3 wives.
Now tell us what all are the evidences from your end to show that there were 3 wives. Including the documentary evidences. You had exhibit 3, right? Then you had exhibit 9 and exhibit 10. These cannot be the documents to show that he had 3 wives, because that was not the issue before the court.
And also that JB 25 and 26 was the name of Jamruti Khanam, and 5 and 6 was recorded in the name of Aliman.
Which property was recorded in the name of Jamruti Khanam?
JB 25.
JB 25.
25. In the table I have mentioned 25 and 26.
25 and 26. Where is that recording? Which document do I get this? JB, you see, Schedule A has JB plot number 26, Schedule A, and Schedule B is JB plot number 25. This was recorded in whose name?
Jamruti Khanam.
Jamruti Khanam, no?
Yes.
I just want to know, is there any property recorded in the name of Firoza Khanam? If no property is recorded in the name of Firoza Khanam, where does the 3rd wife come from?
Because
On the date of death, as per the plaintiff, he had 3 wives, right? And there was a partition.
Jainuddin inherited that, the same property.
No,
my
no.
claim is
There were 3 wives.
Yes.
As per your case, it was the property was divided equally amongst the 3 wives,
3 wives.
right? Where is the recording in the name of Firoza Khanam?
Firoza Khanam, Your Ladyship, they had only one son. So Zainuddin inherited the entire property and therefore it was recorded in the name of Aliman.
Aliman, his wife.
Yes, his wife, mother of Abid.
This was which property?
5
Which
and
was
6,
recorded?
JB 5 and 6.
JB 5 and 6. Was it the property of Mirza Bilati Hussain?
That was through Amirul Nisa. and we all are descendants of.
I just want to know Mirza Vilayuddin Hussain had how many JBs? How many JBs did he have? He had 5 and 6, he had 25 and 26. What all? Is there any property of Mirza Vilayuddin Hussain recorded in the name of Firoza Khanum or Jainuddin Hussain? Any property? You see, there has to be, you see, the description of the property so far as this Mirza Vilayuddin Hussain is concerned. Which all are the properties which belong to Mirza Vilayuddin Hussain?
Your Ladyship, in order to show that.
Is it there in your plaint? Is it there in your plaint that which properties belong to Vilayuddin Hussain? I can understand if there is a recording of his property with respect to each one of the three. Then there would be no doubt that there is a partition and some property of Vilayuddin Hussain is recorded in the name of one or the other person.
But your Ladyship, since the first two wives had legal heirs, and to be more specific, made legal heirs, so there is no recording in both their names. Since she was issueless, so which is why there is a specific recording in her name. The other two, there is recording in the name of their legal heirs.
Which is that document? Which is that document?
JV number.
Exhibit C. Exhibit D नहीं है इसमें. Exhibit D यहाँ पे नहीं है. You have a copy of Exhibit D? You just see, Mr. Rahul Gupta, the way you had formulated the additional substantial question of law, without referring to any exhibits, right? And then we pointed out that it is not acceptable. Then you say that if there is any perversity, now you will open the entire Pandora box. Even your additional substantial question of law did not refer to any exhibit. Did it? Did it? It did not.
But one question.
No. No,
One question
I'm
is
absolutely
important.
clueless. You can just start off with this
There is
in any
reversal.
manner and add merely because there is reversal, there is
Reversal
perversity.
for
I
two
don't.
reasons. Because reversal is based on misconstruction of the document.
But that is not your additional substantial question of law. Even your proposed additional substantial question of law is not referring to any misconstruction of document. Even your additional substantial question of law is not referring to any.
I wrongly framed that.
Wrongly framed for you.
But-
Do you suffer
but-
because of that?
No, but-
Why should we bother for you?
But your Lordship had allowed us.
If a counsel like you would say that it was
Nahi.
wrongly framed, then I have nothing to
Wrongly
say.
framed me. What I am proposing is whether there is a misconstruction of exhibit
What you're
3
proposing, can you propose it like this? In a second appeal?
during hearing, if you
Not during hearing, it is
Fine.
not, no, I am not going to enter into this Pandora box and examine all the documents and the oral
only
evidences.
3
No,
documents
what
are
all
saying.
the,
Only 3
there are other documents also on record. Not only those documents, there are other documents also on record. Right? That the exhibit 3, 9 and 10 are not the only documents.
There are other documents,
Okay.
but these 3 documents, 3, 9 and 10 are the document on the basis of which absolute misconstruction of those documents. And exhibit D also. D is very vital document. D is itself says, and it is being discarded on the ground that they are not claiming through Amjadi. Totally misconceived reason given by the applicant. Now,
No, I'm not
105 only says, Your Lordship, 105 only says that if the High Court finds, it is not what I
What a
find
waste
or-
of time. But I'm absolutely clueless. You can go on and on like this. That is not the additional substantial question of law which you suggested also. You are arguing beyond what you suggested. You are arguing beyond what you suggested, Mr. Rahul. This is not done.
But it was.
You are absolutely arguing beyond what is suggested.
Your Lordship had said that those were questions.
No, you see that is always there.
If
If you see on that day I was not willing to frame this substantial question of law, you withdrew it. You did not say that it has not been properly worded, right? But if those questions of law which you suggested, they were not relating to any perversity.
But this is the liberty which has been
No,
given.
liberty that. But I'm
However,
not.
if it is observed that during the course of hearing any perversity comes to light, then certainly the court can always frame us. This is what I am pointing out.
This is
Then
the
my-
settled law.
My proposal is that whether there is any misconstruction of exhibit 3, 9, 10 and exhibit D leading to the perversity in the implement. Because this is the only question which I have. Because trial court's judgment has been reversed on misconstruction of all these exhibits. Otherwise, that judgment would have stood. And after withdrawing this, if I would have filed, this would have not been. Therefore, I started hearing.
You are representing, who is representing Mirza Abid Hussain? You. Read the plaint.
Plaint.
Plaint of title suit 2 of 85. Exhibit 3.
I'll read entire.
No. You said that Mirza Yusuf Hussain
Had 2 wives. This is the son
who is
of.
Mirza Yusuf?
No,
Yusuf
he is the
Hussain?
son of from the first wife. This portion is not necessary. There is no such statement. Even the appellate court has said.
May I submit one thing,
Why you?
regarding the title suit 2 of 85 matters. One second appeal is still pending hearing before this honorable court relating to the same parties, in which genealogy was there.
Which is that appeal?
That is 490, that is first time. Except
That is
for 498, that is still hearing.
Yes, madam, I was just asking you, which is the evidence on record to show that he had 3 wives? Which is the evidence on record? Because you are the plaintiff, you have to prove your case. Which is the evidence on record to show that he had 3 wives? Apart from Exhibit 3, Exhibit 9 and Exhibit 10. So this you need to answer. Since you claim that he had 3 wives, so you show the evidence on record. Right.
Yes, my leadership, I agree. If I may just say that the finding of the civil appeal shall be said to be perverse if it completely defies logic.
Appreciation of Exhibit 9 and 10 completely defies logic. Because Exhibit 9 and 10 could not be the basis to say that he had 3 wives. That was not the issue. Genealogy was not the concern. That was not the issue before the court. The other case is Exhibit, which is the other case, 85?
That is
Oh,
with respect
defies
to
a-
title suit 85.
So that is the document which your lordship was reading.
Just. The original plaintiff in the other suit was Jainuddin.
BJP R branch.
Yes?
R branch.
Branch or Jainuddin?
Yes.
Jainuddin or the
Abid.
Abid Hussain?
Yes. He had filed a suit that please declare the collusive decree which the branch of descendants of the first wife, they had obtained a partition suit decree without pleading us as a party. And when the same was being executed, we were found in possession and there were several other persons. Then we filed this title suit 285 for declaration that it was not binding upon us. It was void and it was not binding. That was
So, madam, you just try and find out. And 12:30, the time is over for this second appeal now. We have order 41/11 proceedings to be taken up now. But you just try and find out as to what is the evidence led by you. Even if there is an iota of admissible evidence, I will just not entertain their addition substantial question. But if there is no evidence and you are relying upon only these three documents primarily, then it is a difficulty. Because they need not prove. Exhibit D exists or not, does not exist makes no sense, right? But you have to prove that there were three wives. And what is the clinching evidence so far as this aspect of the matter is concerned? That should be sufficient. Even if one evidence is there, you just find it out from the records. Which is that evidence? Right? If there is a statement in the evidence of the plaintiffs which has not been cross-examined by them, or even that we can entertain, right? Because not only the documentary evidences, we'll see all the oral evidences also. Because when we talk about perversity, then we'll see everything. If there is only one sustainable evidence to sustain your plea that there were three wives, we will not frame substantial question on this. How much I'll give you time for you tomorrow, right? I'll post it day after. Not longer time than this.
Documentary or oral evidence?
Yes, whatever it is, documentary or oral evidences which has been relied upon by the court. The trial court must have relied upon. So you find it out from the trial court's judgment, which oral evidence the trial court is relying upon and which the oral evidence the appellate court has omitted to consider. Right? That should be sufficient.
For that, you could have framed initially itself without
No,
framing.
first,
If it is framed and they
first I have to be satisfied that there is a perversity. It is your duty to demonstrate that there is a perversity. But still I am asking her.
I don't want to file another application.
There
Because
is no question
that-
of fighting.
that-
I will not entertain it also.
No, that liberty is there in para 4. Therefore, I was saying that if the Honorable Court finds that there is a point involved, then it may be framed. That is all. It may be answered against me also. But without framing, but subjective. I think that I'll pray that under section 105 proviso, the Honorable Court may exercise that power and frame it, and then they may answer. Because no doubt there is perversity, at least with regard to construction of all these exhibits have been discussed. And it is a reversal on which was discussed by the trial.
3, 9 and 10.
3, 9, 10 and Exhibit D.
D.
D. Exhibit D is the document, their own document which Amjadi had filed before in our case, where she had said about.
Then if she is able to demonstrate that there are materials on record to otherwise sustain, then she'll have a case.
Yes, absolutely, absolutely. They'll have a case.
Yes, madam, that should be sufficient. We frame, you see 3, 9 and 10. D. We frame an issue on this, and if you are able to satisfy that the case is otherwise sustainable on the basis of evidences placed on record, then we'll hold it in your favor. But Exhibit 3, 9 and 10, these 3 documents cannot be used to show that there were 2 or 3 times, whatever it is. Correct? Here the Learned Counsel for the appellant has submitted that the Learned Trial Court had recorded a finding that there were 2 wives. Trial court had recorded a finding that there were 3 wives. Okay. The trial court had recorded a finding that there were 2 wives,
And they had failed to establish.
and the Learned First Appellate Court had reversed the finding by holding that there were 3 wives. The Learned Counsel submits that at the time of considering the documentary evidences placed on record, heavy reliance has been placed on Exhibit 3, 9 and 10. 3 was the plaint, 9 and 10 is the judgment of the trial, plaint of the earlier title suit number
285.
2 of 1985, 9 was the judgment of the trial court passed in the said case, and 10 was the appellate court's judgment. He submits that in the plaint there was no mention that Mirza Vilayatin Hussain had 3 wives, although in the appellate court's judgment it was recorded not as a finding but as a submission.
As submission on our part.
But as a submission that there were 3 wives. And the same was the recording before the Learned First Appellate Court also. The Learned Counsel has submitted that the same cannot be construed as an admission. He has also submitted that the genealogy was not the issue, that there was no such issue in the said trial as to whether Mirza Vilayatin Hussain had 3 wives or he had 2 wives. He submits that reliance on Exhibit 3, 9 and 10 is especially misplaced, and therefore the judgment suffers from perversity. Judgment of the Learned First Appellate Court relying upon these documents suffers from perversity. The Learned Counsel has also submitted that in the Exhibit D, Amzadi Begum, who is descendant of the plaintiff, right? Amzadi Begum, who is descendant of the plaintiff, had disclosed that
Ancestor,
predecessor
predecessor
in interest of the plaintiff had disclosed that Mirza Bilatin Hussain had only 2 wives, and merely because the sequence of mentioning the name of wives is not in order, the said document has been discarded. The Learned Counsel submits that such approach of the Learned First Appellate Court is also perverse. What was important was as to whether Mirza Bilatin Hussain had 2 wives or 3 wives. The sequence of the wife is not relevant. He submits that on account of misconstruction of Exhibit 3, 9, 10 and Exhibit D, an additional substantial question of law be framed. He has referred to the earlier order passed by this court and has submitted that it has been observed that if during the course of hearing any perversity is pointed out, then an additional substantial question of law can be framed. The Learned Counsel for the respondents has opposed the prayer and has submitted that construction of document. The Learned First Appellate Court has construed the documents, and therefore the additional substantial question of law need not be framed. After hearing the Learned Counsel for the parties and considering the aforesaid facts and circumstances, particularly the fact that the issue as to whether Mirza Bilatin Hussain had 2 wives or 3 wives was not subject matter of consideration in the earlier title suit number 2 of 85, and prima facie on the perusal of the plaint filed in the said title suit, there is no mention of the fact that Mirza Bilatin Hussain had 3 wives. This court is inclined to frame additional substantial question of law to the following effect: whether the finding of the Learned First Appellate Court in coming to a finding that Mirza Bilatin Hussain had 3 wives and thereby reversing the finding of the trial court that Mirza Bilatin Hussain had only 2 wives, the appellate court has committed a perversity by construing Exhibit 3, 9, 10 and D. So when do we post it further? Day after?
Just 2 days time.
You ask your litigant. Your litigant is here. You ask him. परसों सुनवाई करें आपकी परसों सुनवाई करें? ओके, वेडनेसडे. You see, now the point is, first I will decide the other case. उसी में हमको पता चलेगा कहानी क्या है.
वो
दूसरा वाला.
ठीक है.
इसीलिए पहले हम उसको डिसाइड करेंगे, क्योंकि now this is entirely coming on that, right? If I say anything over there regarding 3 wives, उसमें सुप्रीम कोर्ट चलेगा.
यही लोग हैं.
अच्छा, हाँ, उसमें
सुप्रीम कोर्ट करेगा. दोनों को एक साथ रख दीजिए. उनमें कुछ समय दे दिए, दोनों को एक साथ
हम फाइनल कर हो जाएगा दोनों का। उनमें भी
वो उसमें क्या चल रहा है, उसमें क्या चल रहा है?
उसमें
नोटिस हो गया उसमें? आपका एडजर्नमेंट नोटिस आप दिए हैं? हाँ। अच्छा एक बात बताइए, आपसे हम जानना चाहते हैं, जब दोनों के साथ सुनवाई का ऑर्डर है तो आप 10:30 बजे आके क्यों नहीं बोले कि दोनों केस का साथ सुनवाई होना है, उसमें 3 वीक्स टाइम दे दीजिए? तो वो केस अलग से एडजर्नमेंट हो जाएगा। विद का ऑर्डर है ना सुनने का, तो वो अलग से एडजर्नमेंट हो जाएगा।
नहीं, उसमें पहले
विद नहीं है।
अलग कर दिया गया।
लेकिन हाँ दोनों एक दिन पोस्ट हुआ है।
इसी दिन कर दीजिए,
Because
ये तो
only one thing I must make it clear. नहीं एक चीज क्लियर कर दे रहे हैं, because दोनों का सूट सेपरेट, एकदम सेपरेट सूट से सेपरेट अपील यहाँ आया है, इसी के लिए दोनों को साथ।
इसमें एक है कि आप हमको 5 मिनट 2 मिनट का बोलने का मुझे मौका दें। ये मिर्जा विलायत हुसैन का संपत्ति सारा अलीमत का नाम में जेबी नंबर 5 जेबी नंबर 6 हो गया। अशरफ हुसैन का जेबी नंबर 6 जेबी नंबर 7 और जेबी नंबर 25 और 26 है जमुती का, जिनका जो सीएफ था वो बंटवारा 1932 पे हो चुका है। दोनों पर एक साथ है।
तो आप लोग का सुप्रीम कोर्ट में क्या हो रहा है? आपका बन गया सब्सटेंशियल क्वेश्चन, वहां पर नोटिस हुआ? अभी तक डिफेक्टिव चल रहा है।
डिफेक्टिव नहीं है,
हमको तो डिफेक्टिव दिखा।
हम लोग को भी दिख रहा है डिफेक्टिव।
ये जो लास्ट डेट के डायरी नंबर दिए थे ना, वो एक्चुअली नहीं है, वो 419 ऑफ 2026 है। ये बच्चे में रिकॉर्डेड डायरी नंबर है, सीएनआर नंबर को डायरी नंबर, ये डायरी नंबर है 419 ऑफ 2026, बट इट वाज फाइल्ड ऑन 5/1/2026।
देखिए इतना पुराना मैटर है ना, आई एम वेरी कॉन्शियस ऑफ दिस फैक्ट कि हमसे कुछ गलती नहीं होना चाहिए ऑन फैक्ट्स। दिस इज व्हाट आई एम कंसर्न्ड अबाउट।
नहीं ठीक है, they should have tried it faster in Supreme Court. Defective छोड़ना।
कब का ऑर्डर,
दोनों को रख दिया।
कब का ऑर्डर है ये?
ये अक्टूबर का है।
29/10 का,
अक्टूबर का ऑर्डर 3 महीना हो गया ना।
29/10 का। 3 सप्ताह में दोनों को रख दिए, दोनों का एक दिन सुनवाई हो जाएगा, दिन भर आप सुनवाई करके खत्म। दोनों को एक साथ रख दिए हुए, आपसे प्रार्थना कर रहे हैं दोनों को 3 सप्ताह के दे दीजिए, इनको भी हम बढ़िया से तैयार कर देंगे।
इतना जो ये ऑर्डर शीट इतना मोटा हो गया, क्या कर रहे थे इतना सारा?
एक बार मेहरबानी आप हमरे ऊपर कर दिए दोनों।
79 एडजर्नमेंट्स, हम तो बहुत परेशान हैं।
मुकदमा
79 83 एडजर्नमेंट्स।
जी, हम तो आपको बता दें जिनको जो हिस्सा मिलना था वो 1932 में हो चुका है।
कोई बात नहीं, ऐसा आप पीछे चले बैठिए। बताइए मिस्टर, आप देखिए आप लोग सीनियर लोग हैं, आप लोग बताइए इतना पुराना लिटिगेशन में आखिर इसको कैसे
रीजनेबल टाइम तो मिलना चाहिए था, बट 29/10/2025 अभी 4 महीना से ऊपर हो गए। रीजनेबलनेस का एक तो एक्सटेंट एक लिमिट होता है। If they keep their petition defective there, then they cannot seek adjournment before this.
डिफेक्टिव फाइल करके छोड़ दिए हैं आप, बस यहाँ पे खाली सूट 88 का, एक तो 88 का है, दूसरा 85 का है।
But I only pray that conditional order may be passed, otherwise I'll start arguing on the next. Whatever time is it. If they are unable to bring any order, then
इसमें क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ बना दिए, क्या एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ बना दिए? उसके बिना बहस कर लीजिए, तो जरूरी है इसको प्रेस करना, तब इनका केस ही इन्फ्रक्चुअस हो जाएगा ना आपका केस इन्फ्रक्चुअस, वही ना इन्फ्रक्चुअस कर देते हैं आपका केस। पूछते हैं इनसे, बिना उस सब्सटेंशियल क्वेश्चन ऑफ लॉ के बहस कर सकते क्या? आप लोग भी नॉन सीरियस हैं, 2000 अक्टूबर का ऑर्डर लेकर आप लोग बैठे हुए हैं।
No, that is important. Because that was the suit for. This, the question of law that was formulated was because there was a reversal. Whether the decree passed in title suit number 6 of 1976 is void, collusive, inoperative and not binding upon the plaintiff, because we were not included in that suit of 1976 and it was sought to be enforced against us. Therefore, we had filed a suit claiming exact this relief only, that it may be declared that the same is not binding upon us and the same is void, inoperative.
कोई भी सब्सटेंशियल क्वेश्चन ऑफ लॉ उसमें जीनोलॉजी को लेके तो नहीं बना है।
नहीं, उसमें तो इन्वॉल्व भी नहीं ना, क्योंकि उनका ब्रांच जो है that is not in dispute कि वो
We'll post it for day after tomorrow for further hearing. We are not going to wait for that judgment. We'll not bother about it. उनका अपना आपका केस एडजर्न कर देते हैं। You argue for this. Wednesday day. Tomorrow is Tuesday. Wednesday. You want more time?
1 week.
At this, the learned counsel for the respondent prays that the matter be posted on next Wednesday for the final hearing of this case. Post on next Wednesday.
At 10:30. 10:30.
At 10:30, of course 10:30. अब शुरू हो गया है तो आप जितना भी लंबा क्यों ना चले, we'll hear it. Unless you also want to go and challenge. We do not know. Your litigant may. We do not know. If you want to challenge, you please challenge it. Don't keep wasting our time. Then we'll adjourn it for another 6 months. And then you'll have another bench to hear the matter. Correct? So that is one way. आपका केस कब रख दें बताइए? By way of last indulgence. इनका सीरियल नंबर कौन सा है?
मेरा prayer रहेगा, if they are unable to bring anything, then I will start argument.
सीरियल नंबर कौन सा है?
First, serial number.
Is 1993 वाला? The learned counsel for the respondent has submitted that the matter is pending before Honorable Supreme Court. Counsel for the appellant, you are the appellant,
Yes.
has opposed the prayer for adjournment and has submitted that the order was passed by this court in the month of October and the matter is pending. He submits that by way of last indulgence, adjournment may be granted. Post on 9th of March. आप लोग सिनॉप्सिस नहीं बनाएंगे, इतना सुनने के बाद तो अब सिनॉप्सिस बन जाना चाहिए ना आपका।
किए हैं लेकिन उसको कंपाइल करके एक
Yes, madam, will you be able to prepare some synopsis?
Yes, sir.
Look at the evidences very carefully, right? Particularly on the point of genealogy, because they are claiming perversity. You take care of that.
दो केस टू भी मेंशन है।
मेंशन में क्यों था मैटर?
डेट था ये 18
2:15 बजे करेंगे, अभी आपको ऑर्डर पर बनेगा।
Under heading for hearing under order 41 rule 11 of CPC item 7, second appeal 442/73.
You were directed to supply memo of appeal, your lordship.
ऑर्डर 41 रूल 11 में आपका
Now
क्या?
we don't have any role.
So you don't have any role to play. You just have a seat. Yes, please.
Suit was this plaintiff's appeal. Suit was instituted for declaration of right time of interest on basis of adverse possession.
The plea was adverse possession. Where the
Yes,
plaintiff.
my case is that my vendor of my predecessor in interest, he was the owner of plot 21.
It's a Khas Mahal property. It's a Khas Mahal property.
One plot is 1361, that is said to be Khas Gair Majua Malik Khas Mahal property. It was settled with one Gokul Mato in the year 1960. Gokul Mato further sold it to one Sardar Mahendra Singh.
No, but it's for Khas Mahal property. You have
A
to.
portion of, of course, it is the entire suit property is not Khas Mahal property. Only 1361 is Khas Mahal. It is said to be Khas Mahal property, but that was settled with one Gokul Mato. And
May be settled,
And
but
he
it
was-
is only a lease.
and
Even
he-
if it is settled,
and thereafter he sold it. The defendant
he
was-
might have sold it. But you are seeking adverse possession. The owner of the property has to be party.
The defendant number 1 claims, sorry, 13 yes, plot 1361 is said to be Khas Mahal property, but now it is said to have been settled and thereafter further transfers have been made. So
Both the properties are relating to 1361.
no, one is plot 20.
Lot number.
Schedule A is plot 20, Schedule B is plot 1361. Now both the courts finds that I am in possession, but holds that since I have not arrayed the real owners as defendants, therefore adverse possession, title by way of adverse possession cannot be declared. My case is that the real owners never disturbed me, and these defendants are claiming through the real owners. So long as the real owners were there, they never disturbed my vendor. But at present, these defendants, they claim through the real owner.
From where do you say that the defendants are claiming through the real owner?
Yes. This one difficulty in this, there is an order on 16/12/25. May tell you that one, there is an order on 16/12/25 by which respondent 1/4 the appeal is between when we have awaited against respondent 1/4 16/12/25. Thereafter, we have taken steps for substitution of other respondents, but so far as this respondent is concerned, 1/4, we have not found, we have got no information regarding legal errors. So, steps have not been taken for setting aside the verdict.
The second appeal of 2003 should be adjourned on this ground.
No, this is a technical difficulty that after going to the records, it came.
We are not going to adjourn it. इसको केस को सड़ाना बोलते हैं ना, यही है।
बीच में DLP वगैरह
हाँ, वही।
तो
केस को सड़ाना जिसको बोलते हैं, रॉटन 2003 मैटर, सब्सटैंशियल क्वेश्चन ऑफ लॉ पर अभी तक आर्ग्यूमेंट नहीं हुआ, चल रहा है केस। Rotted till it completely decays.
It came to us at stage when
I'm not telling you, I'm telling the litigant and whosoever has handled this case. 2003. How many years have passed? 23 years for a case. I'm not satisfied with you.
in nutshell this is the case. Now, if the leadership may kindly see the case of the defendants, appellate court judgment and referring to para 6.
Yes.
Now, he claims that he purchased in the next page, there is defendant number 1 has been coming in possession over 6.5 decimal of plot 1361 since before vesting of Jamindari. The defendant number 1 purchased 10 decimal of land of plot 20 by registered sale deed number 6371 dated 12/7/79 along with Srimati Saraswati Devi, Mahila Kalakuan to Sri Ganori Thakur Secretary from Ram Pyari Tiwari, Jaisari Tiwari, Ramakrish Tiwari and Rajeshwar Tiwari, the ex-landlord and the owner of total of the aforesaid plot number 20. So far as defendant number 2 is concerned, it is there in internal page number 2. Gokul Mathur, who admittedly got rightly settlement of 13 decimal of land of plot 1361 from class 1 officer in or about 1960. Gokul Mathur transferred 13 decimals of land by sale deed number dated 1774 in favor of Sardar Mahendra Singh, who exercised the peaceful possession over plot number 1361. Gokul Mathur remained in possession.
Yeah, you have taken all the required pleas of adverse possession.
Yes.
Show me. Show me that you have disclosed who is the actual owner of the property. Show me the date on which your possession was, according to you, was adverse. Show it to me. What is the date of your adverse possession?
59. And this, the case of the, it is there at page para 5, internal page 3, appellate project.
Yes.
Case of the plain, case of title number as a word in the claim that plot number 21 under Khata Petitko village, Varkola was purchased by Srimati Budan Devi as per registered sale deed number 690 dated 751, executed by Hanuman Das, Bharatdas and Sher Kumar. Contiguous north of plot 21 situates plot 20. In 1947, contiguous northern portion of plot 20 measuring area of 30 decimals was amalgamated in plot number 21 by the vendors of ancestor of the plaintiffs. Contiguous northern portion of plot number 1361 under Khata 90 of village Udma measuring area of 6 decimals land was also amalgamated by the vendors of the ancestors of the plaintiff in their plot number 21 land. The rightful owner of plot 20 of village Varkola and plot number 1361 of village Udma allowed the vendors of the ancestor of the plaintiff to perfect the title to adverse possession, and they did not give any cause of action to the plaintiffs for instituting the suit against them, making them defendants. By virtue of such amalgamation in or about 1947, and 45 respectively forms one compact block. Since then, by their total continuous peaceful and hostile position against the riots of plot number 20 and 1361, the aforesaid building, and thereafter Budhan Devi perfected title with respect to the amalgamated portion of land of adverse possession by the year 1959. When Budhan Devi died and on her death, her sole heir and successor, the father and husband of the plaintiffs came in possession of plot 21 along with amalgamated portion of plot 20 and 1361. The further case of the plaintiff has already claimed that the Khasna officer made rightly settlement of land bearing plot number 1361 one Gokul Mato of village Suna in or about 1960, by which time to adverse possession late Budhan Devi had already perfected her title with respect to 6.5 decimal of plot 1361 and on remaining 6.5 decimal land Surendra Pal had come in possession. Thus, settlement in favor of Gokul Mato in respect of 15 decimal of plot 60 or plot number 1361 remained confined to paper only, and the said settlement never came in actual physical possession of plot 1361. Surendra Pal constructed his house over the remaining 6.5 decimal of plot 1461. Yet Budhan work had perfected her title over 6.5 decimals of plot 1361, and Surendra Pal had constructed his house over the remaining 6.5 decimal of plot 1361 to be described in Schedule B. Again, in spite of the fact that Gokul Mato could not come in actual physical possession by virtue of settlement in his favor, and the so-called settlement which remained confined paperly, he executed scale of the same in favor of one Sardar Hansraj Singh, showing a fictitious consideration in the same in the year 1985. Sardar Hansraj Singh executed a showing scale in favor of defendant number 2 without consideration to a fictitious consideration amount has fictitious consideration amount has been shown in the same. Budhan Devi died in the year 59 and father of 24 succeeded her as being next relation. The husband of Budhan Devi was own uncle of father of 24. Budhan Devi died without any issue. Hence, the property of Budhan Devi, including the land of plot 21 along with the small land devoid for father of the plaintiff number 1, who died in 71. Thereafter, the plaintiff has his only son succeeded who was the property along with mother and original plaintiff.
Budhan Devi is a party,
No, she has passed. She died in 1959.
and her legal years are not.
Legal years are, she died issueless. So her act, nearest act.
Where do you say that she died? Who are the defendants in this case?
Defendants are purchasers from the Gokul Mato and purchasers from the ex-landlord. Defendant number 1, so far defendant number 1 is concerned, purchaser from the ex-landlord, and defendant number 2, purchaser from the second Gokul Mato. Gokul Mato sold it to one Sardar Hansraj Singh, and thereafter that Sardar Hansraj Singh transferred it to.
Not a case for notice.
Ingredients of adverse possession has clearly been pleaded and made up. Court finds that I am in possession. Both the court
You remain in possession, nobody is there to evict you. You remain in possession, enjoy the possession. What's the big deal about it?
Now they have started disturbing my possession after the judgment DP. I have filed an interlocutory application for injunction. I have already, there is a IA pending. But case for of adverse possession has been clearly pleaded and made up.
You see, there are 3 properties. One is plot number 20. Other is plot number
1361.
1361.
And so
1361 is Khasnail property.
But settled in favor of Gokul Mato,
Maybe.
who has transferred it.
Maybe. He might have transferred it, but government is not a party to it.
But once government settles it, now the current court did not point to the nature of settlement.
That's
Whether
Khasnail property, it is your case only that it's a
It's a
Khasnail.
Khasnail property, but it has been settled. Now, whether the settlement is
No.
permanent in nature,
So therefore the government was a necessary party. Therefore the government was a necessary party because government is a paramount owner so far as this property is concerned. So far as plot number 20 is concerned, whose property is this?
it is said to be the ex-landlord's property purchased by defendant number 1.
By which sale deed?
Well, 779.
You are in possession since?
My vendors since 1947. I purchased Budni Devi purchased in 51.
From this is 12/7/79. Where it is?
Page internal page 6. Towards mid. Sale deed number 6371 dated 12/7/79.
Shanti Devi, Ganori Thakur and Shiku Mandal. Right?
Yes, along with Srimati Saraswati Devi, Mahila, Shilpi Kala.
They purchased different plots, different areas of this
different
plot.
area. Shilpi Kala 1 to Shri Ganori Thakur, secretary from Ram Pyari Tiwari, Jaiswari Tiwari, Ramprith Tiwari and Rajeshwari, ex-landlord and the holders of the associate plot number 20.
And these people are all parties.
Defend number 1 of the purchasers, because defend number 1 contention is that I am in possession, the case purchase the portion of plot number 20. Total plot number area of plot number 20 is 93 decibels.
This is by virtue of one sale deed.
There are 2 different sale deeds, but we are not concerned. We are only concerned with 30 decibels of plot number 93, which is adjacent not to plot 20.
30 decibels of plot number 20.
20, sir. Yes, 20.
Okay, which is a part of which, who is party over here?
The defend number 1.
Defend number 1. What is his name?
Defend number 1 was now substituted Ramkesh Mathur.
He is related to Shanti Devi.
The government is the defend number 1 purchased 10 decibels of plot number 20 by registered sale deed number such and such along with Srimati Saraswati Devi and Mahila Kala Bhavan to Ganori Thakur, secretary from Ram Pyari Tiwari, Jaiswari.
So this happened in 1979.
1970.
And you say that against the landlord, your possession became adverse. And therefore this sale deed is also bad in law because your possession had become adverse. But you do not make the landlord as a party in the proceedings. Correct?
My case is that the ex-landlords never disturbed my possession or my vendor's possession. And these defendants are claiming, defendant number 1 is claiming to the ex-landlord.
You heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 13/6/2003, within that decree signed on 25/6/2003, passed by the learned third additional district judge, Palamu, dismissing the title appeal number 5 of 1995 and confirming the judgment and decree dated 26/11/1994, decree signed on 7/12/1994, passed by the First Edition Municip Daltonganj entitled suit number 12 of 1988. The learned counsel for the appellant has submitted that the suit was primarily for declaration of adverse possession with respect to two schedules of the plaint. Schedule A was relating to plot number 20 and Schedule B was relating to plot number 1631. He submits that both the courts have dismissed both the courts also have found the plaintiff in possession of the property but have dismissed the plea of adverse possession primarily on the ground of non-joinder of necessary party. During the course of arguments, it transpired that so far as plot number 1631 is concerned, the same was Khas Mahal property of the government, but it was asserted that the Khas Mahal officer made Rayati settlement of the same with respect to 2-1 Gokul Mehto. And by the time the settlement was made to Gokul Mehto, the predecessor in interest of the plaintiff had already perfected the title by way of adverse possession. Yeah. So far as the plot number 20 is concerned, it has been asserted that the defendant number 1 had been in possession right from the year 1957.
Defendant claims to have been in possession prior to that settlement.
Okay, just a moment. The plaintiff was in possession right from the year 1957.
47. Plaintiff's vendor in 47. Thereafter, the plaintiff's predecessor purchased in 51.
Plaintiff's vendor was in possession of the property From where do you read this? I'm not able to get it.
Edition kindly take para 5.
I'm there in para 5.
In 1947, contiguous northern portion of plot number 20, western 30 decimal was amalgamated in plot number 21 by the vendors of the ancestors of the plaintiff.
It was amalgamated, no?
Yes.
It was not purchased.
No, so this one, all three plots form one composite block, which was purchased by the predecessor in title of the plaintiff in 1951.
With respect to plot number 20, the learned counsel has submitted that the predecessor of the ancestor of the plaintiff had amalgamated the property with their own property way back in the year 1959.
47. Not the ancestor of the plaintiff. The
Predecessor
vendor of ancestor of the plaintiff had amalgamated it in 1947 and transferred it in 51.
फिर से इसको लिखिए. The learned counsel for the appellant has further submitted that the rightful owner of plot number 20 and plot number 1361 allowed the vendors of the ancestor of the plaintiff to perfect their title through adverse possession, and they did not give any cause of action to the plaintiff to institute the suit against them, making as defendant. It was their further case that by virtue of such amalgamation in or about the year 1947 and 45 respectively, the three properties, that is plot number 1631, plot number 20 and plot number 21, formed one compact block, and since then their possession is open, continuous, peaceful and hostile against the rayats of plot number 20 and 1361. And therefore the plaintiffs had forfeited their title with respect to the suit property through adverse possession. The learned counsel has submitted that the finding of the learned court that the suit was bad for non-joinder of necessary parties is not in accordance with law. That's all. I reserve the order.
What's the probability the appeal has abated as a whole?
The learned counsel for the respondent has submitted that on account of non-substitution of respondent number 1 within bracket 4,
Yes.
the entire appeal has abated.
Yes.
You have to say anything to this?
The abatement against one, if there is joint and common interest, it will abate against the whole.
There are two sets of defendants. Both are claiming different through different instruments and different interests. It will not abate as a whole.
Two set of defendants, please.
This was defendant number 1 and defendant number 2. So defendant number 1 was claiming by a different instrument, different area, and defendant number 2 was claiming different
To this, the learned counsel for the appellant has submitted that defendant number 1 and defendant number 2 were claiming through different instruments,
Their interest is not joint.
and their interest is not joint.
In the event,
They filed their joint written statement,
no, separate.
and they had also filed their separate written statement, and therefore the deceased respondent was in relation to
Defendant number 1,
defendant number 1, which was in relation to property,
plot number 20, plot number 20.
which was in relation to plot number 20. And therefore, it cannot be said that the entire suit, the entire appeal has abated. The appeal survives at least in connection with plot number 1361. Correct?
It is in the event leadership dismisses as abated, then I may be given an opportunity for setting
No,
it.
we will not give you any opportunity. You see, 1361 otherwise also is difficult. 20 if abated. Matter
20
is.
also he claims only 10 decimals, not entire 30 decimals.
Item 32, second appeal 603 of 2017.
And is pending before the learned court will also. Was stated that is what for the lesser right identification and confirmation and in this. So was partly declared in favor of the plaintiff against that. That is the allowing of the declared also. Respondent prefer appeal allowed also. There is reversal of the judgment. The land is so far as the plaintiff case is lost. The land is recorded in the name of Ikhu Kahar. उसने मिला करेंगे खतियान एंड रजिस्टर्ड टू लॉट्स एंड दिस सेल गोवर्धन Bhavani and plaintiff are the grandsons of the Govardhan.
There was a compromise
Yes,
with Govardhan Ravani
Yes, the
way back in
compromise-
1968.
Yes, compromise decree is not applicable because the land is not transferable lots. As per section 20 of the SPT Act.
If you say it is fraudulent, you have to take steps within time, no?
Yes, Bhavani, can we see the rent receipt was issued in favor of the plaintiff of lots till 2002 lots, and in the year 2003 lots, they obtained the rent receipt lots. The plaintiff came to know about the rent receipt lots. The plaintiff instituted 5 lakh case under section 144 lots, and for declaration of right of interest in the year 2003 itself.
So 2003, 68 से 2003 कितना साल हो गया?
Because the plaintiff was not aware lots.
What do you mean not aware? You were not even born. Plaintiff were not even born at that point of time.
So because the rent receipt was being issued in favor of the plaintiff 2002 lots, either 2003 lots, when they entered and the land is
The
not
plaintiff, out of the 3 plaintiffs, one was 2 years old, other was 3 years old, and the third one was not born.
Since the compromise,
See, your father entered into some compromise.
since the compromise decree was obtained by claim fraud lots,
How do you say fraud?
That is the statute lots.
How do you say fraud?
Yes, I am also denying judgment lots.
You see, even if it is fraud, you have to take steps. You have not taken any steps. It's not your case.
Because the plaintiff came to know about the judgment loss, the rate is only in the year 2003 loss. उसका तुरंत 2003 में suit instituted. The land was not transferable loss. And they see and relying on judgment loss. They are one thing on what they are saying loss that the land was transferred by Bhikkhu Kahar, not in paragraph 13 loss, not said कब transfer किए. By which mode it was transferred or said it was and paragraph 27 of the WS document, they are claiming the land on the basis of adverse position.
Who are claiming? You are the plaintiff, no? You satisfy your case.
Yes, sir, because
There was a compromise on 9/7/1968 with your father.
because that was against the statute policy. I am relying on judgment process passed by this honorable court. see paragraph 7, 8.
Yes, what is it?
The ground of municipal for final commission is
71A.
The section 20 में वही same चीज होता है. That is not transferable. Moreover, the appellants are taking the ground of compromise decree to support the date of disposition, but the issue of decree passed by the competent court here for consideration before the court in several cases, and this court has come to conclusive find that the respect to a decree passed in the suit of compromise and the CNT Act will be treated to be fought upon the statute. A reference
The
in
CNT Act कहाँ आप ले आए हैं यहाँ पर? This is not CNT Act.
the ratio will not equal because the section 20 we can be taken and section 20 of the SPT Act also. And the Patna High Court also in the full bench also said that the land is not transferable also. In the SPT, as per section 20 of the SPT Act also, land is not transferable. And the defendants are belong to the non-tribal lots. And the plaintiffs are belong to extremely backward classes. उनको कहीं पर भी देखना चाहिए था कि कहीं पर भी लैंड वाज ट्रांसफर बाय विच मोड्स लॉस. एक जगह बोलता है ट्रांसफर बाय द वीको कहा, दूसरी जगह पैराग्राफ 27 देयर क्लेमिंग ऑफ द लैंड हैज बीन acquired by adverse possession. So both the statement is contradictory. So far as order 23 rule 3 is not applicable in this case. Compromise against the statute also.
Show me some judgment that this judgment will this this provision of secrecy will not apply. Order 23 rule 1A will not apply. Then anybody will you see, if there is any fraud, then somebody has to come forward and say that discovered fraud, and your father entered into a compromise when you were not even born, right? And then you rise up and say that you are claiming your right title and interest.
Because the plaintiffs are in position also. ये 2002 तक हम पोजीशन में 2003 में ओनली दे उनके नाम से रजिस्ट्रेशन इशू शुरू हुआ तब हमको नॉलेज में हुआ दे इंटरव्यू टू परचेज द लैंड्स और डिस्पोज द प्लेंटिफ also. Then they only came to know about that the land was transferred in by way of policy decree also. That is against the statute also.
No, I'm not satisfied. आपको जब मन होगा उठ के आ जाइएगा.
You can see PNGR. So that is decided by the Patna High Court. It says also, I give you that.
पार्टी का नाम बताइए. पार्टी का नाम.
That is recorded in the book.
पार्टी का नाम बताइए जो जजमेंट रिलाई कर रहा है.
Yes. Bahuri Lal Jain and another doctor versus the sub-legal officer. 1972 PLJ 400 full page.
Give me that judgment. देखिए judgment.
Paragraph 14.
सेकंड आपने लिखा था ये देखिए. 2:15 बजे लिखेंगे आ जाइए.